Hi, and welcome to the Law Simplified. I'm Shavin Bandad-Nayaka. I've often said that the law is like the ocean. It's expansive and never-ending, and every single time that you look at it, it's not the same ocean that you really see. The law, similarly, is ever-evolving. Throughout the centuries and the millennia, the substance of the law, the arguments, and the case law that substantiates those arguments have shifted. Now, it's no surprise then that depending on the jurisdiction that you live in, that you're applying in terms of your LLB or GDL qualification, you will see quite often contradictions in the law as well. This doesn't mean, in a sense, that the law is wrong. Rather, the application of it and the way it's looked at might have been different at that period of time or in that place. We have encountered this in our general fundamentals of the law. For example, for those of you who have studied contract law in consideration, in terms of fresh consideration for an existing obligation, we look at two contradicting views in Stilk and Merrick on the one hand, and Williams and Rofe brothers on the other. The same could be true and applied in terms of a more philosophical and jurisprudential thinking. For instance, when it comes to aspects of assisted suicide and euthanasia, different jurisdictions and different cultures view it differently. Whereas in some countries it might be frowned upon, others it's welcomed with open arms. That being said, the reason for this video is throughout your academics and later career in law, you are going to encounter such contradictions. There's going to be two schools of thought. There's going to be different aspects of the law in terms of substance that may be applied. There might even be two identical cases decided completely differently based on one nuanced element. But none of these should change one fundamental aspect in terms of your approach to the law, which is your opinion and your arguments. The genesis of this video and the motivations behind it is because of the very nature of the law, and something that a number of students have come up with and told me over the years, where a certain argument, a certain substantive element of the law that may have been discussed is different to something that they have encountered in their own research. Now, granted, there are occasions in which the law contradicts in a way that is illogical at best and downright unworthy of attention by academics at the worst. But in any of those situations, what's important is not exactly what the jurists at the time, or the academics, or even what the judges had manifested, but rather what you feel is the correct argument to be presented to your given scenario. That is the beauty of the law. No two situations, irrespective of how similar they may seem, is identical. There is going to be at least one element that's going to be different and distinct enough to differentiate it from another outcome or another decision. So the question to ask is not whether the law is wrong, but rather which wrong is appropriate for the given time and the scenario. Now, by that, I don't by any means mean that following the law is incorrect or applying the law is incorrect, but to always put it in context with the argument and the substance that you're applying to your given scenario. You might be submitting an assignment, you might be sitting for an examination, but think of it from your perspective, whether it fits and services the argument that you are proliferating. Chances are, in as many nuanced forms as there's going to be a law in terms of substance, in terms of case law, and even statutes that's going to fit the description that you're looking for. That being said, until the next time that we speak, have fun, stay safe, and as always, obey the law.